and practical reasons, openness, that is access to criminal trial proceedings, is constitutionally required. There is, too, a First Amendment right of access, at least to criminal trial proceedings. As I said, that has been the reasoning of the Richmond newspapers cases, has been extended by the California Supreme Court to civil trial proceedings, but the U.S. Supreme Court has never gone beyond criminal trial proceedings. So it's still, Houchins is still the law. The general rule is still the same, with an exception for criminal trial proceedings. The question to think about, to what extent is there First Amendment right of access? We discovered that. Should the press have greater access to information than the public? They certainly claim that they do. They need it in order to inform us what our government is up to and so on. But the Supreme Court has said, in Houchins' case, and as recently as Citizens United, that the press does not enjoy any First Amendment privileges, rights, access that the general public doesn't have. Should executions be televised? That's a normative question, and you can answer it any way you want. Should they be televised? In the televising executions case that we talked about, there were two issues. One, do the press and public have access to witness executions? Admittedly, they're conducted in the core of a maximum security prison, and that might call to mind Houchins versus KQED. So they don't have any right to go there. But if you look at executions as a government proceeding related to the criminal justice system, then you look to the history and find that executions have always been open to press and public. You look to the functional or utilitarian values of openness. You don't want executions to be conducted in secret. And therefore, by parity of reasoning, using the reasoning of the Richmond newspapers line of cases, you would say that, well, there is a right to witness executions. Then the question is there a right to televise them? And that's a different question. And one of the problems with saying that there's a First Amendment to televise them is there's no First Amendment right to televise trials. The lower courts have decided. The Supreme Court has never decided whether there is or is not a First Amendment right to televise trials. All the court decided in the cameras in the court's cases was that the fact that a trial was televised does not all by itself deny the criminal defendant a fair trial, so that the conviction would have to be overturned. Rather, the criminal defendant has to show that televising the trial specifically, in some specific way, prejudiced the fairness of the trial. Or of the press. Sailing right along. There we considered the speech that Justice Potter Stewart gave, expounding his theory that those four words in the First Amendment made a difference and gave the press a structural, constitutional status or stature that the rest of us don't have, and that it makes a difference in some way. But rebutting Stewart's view on that was Anthony Lewis's piece, in which he took the Stewart thesis and demolished it, basically, showing that the Supreme Court's cases didn't support it. The history, as far as anybody can tell, of what the framers meant by those four words, or of the press, is inconclusive. And Lewis concludes that it would be bad public policy to give the press some kind of preferred position under our Constitution. And then we looked at the Florida Star case, which was the Florida law that made it illegal for newspapers, an instrument of mass communication, is what the law said, to report the identity of victims of sex offenses in order to protect their privacy. And the court decided that that law was unconstitutional, heavily emphasizing the need of the press to report matters of public interest, like the commission of serious crimes in the community and so on, but not relying on the press clause explicitly. It was a big protection for the press because the only people who could be punished under this law were instruments of mass communication. But the court did not, the reasoning of the court was not that the press has some kind of exalted constitutional protection that the rest of us don't enjoy. And then the other case that we looked at was the Bartnicki versus Vopper case, the interception of a cell phone conversation case, and the airing of the intercepted conversation on the radio and the printing of the transcript of the conversation in the newspaper. And the court decided that the radio station and the newspaper could not constitutionally be punished for airing that information, even though it was illegal and everybody knew it was illegal to intercept the conversation under wiretapping laws. And the station and the newspaper knew or must have known that it was illegal to disclose the contents of an intercepted conversation. The court decided that because the media, in that case, were not themselves the guilty people who had done the intercepting, that is, they were completely innocent up until the moment that they actually published the contents of the conversation, and because the contents were of significant public concern, threats of violence in a school board strike, information that the public should know about, because of those two factors, the publications were constitutionally protected. Once again, the court did not rely on the press clause of the First Amendment in arriving at that conclusion. So the questions, do the words "or of the press" in the First Amendment add anything to the guarantee of free speech for all? And the second question, does the press or news media have any First Amendment protections not enjoyed by ordinary citizens? We have to answer that candidly, no, not in a practical sense. The press, as the Supreme Court has decided in First Amendment cases, does not have special privileges that the rest of us don't have. They don't have the right to protect their confidential sources from compelled disclosure to grand jury. They don't have the right to go in jails. They don't have the right to go places that would be a trespass if any of the rest of us tried to go in. So you have to conclude that in the real world, the press doesn't have any special protections under the First Amendment. That doesn't mean, as I said when we were talking about the Stewart-Lewis debate, that those words in the First Amendment are meaningless, that they're just surplusage that should be ignored. I do think that the framers must have meant some kind of acknowledgement of the important role that the press plays in our society, and meant to ensure, at least, that they wouldn't be discriminated against, and that they wouldn't be subjected to prior restraints and so on. Sure, these are protections that we all enjoy, but I think the framers might justifiably have been wanting to emphasize that the press is real important to our democracy and ought to be protected. Nicole? There are none that explicitly rely on the press clause. I mean, as I said when we talked about Miami Herald versus Tornillo, that case, in my view, comes as close to it as any that's ever been decided. That was the case about there's another Florida law that said that newspapers, singling out newspapers, had to print responses, rebuttals, by people, political candidates, who had been attacked by the newspaper, had been criticized, had been editorially attacked in the newspaper. The law required a right of reply, that the political candidate could submit to the newspaper, and the newspaper would have to run it, a response to the attack. And the court says that's unconstitutional. That violates the First Amendment. And the court gave two reasons for that. One is the law exacts a penalty based on the content of what the newspaper prints. The penalty being you have to give up some space in your newspaper to print something that you didn't write and that you don't want to appear in your newspaper. And there's some cost involved in that as well. And the court said even if there's no cost involved, the second reason is that this law intrudes into the function of editors, which is that function includes the discretion to decide what will be published in the newspaper. And the government shouldn't be involved in dictating what a newspaper must print. Well, that's awfully close to saying that the press clause doesn't allow this. It's all focused on newspapers. But the court did not invoke the press clause in deciding that. Juliet?
What is, people don't agree with you for the other press portion of the First Amendment, what is their argument that the framers placed of the press in the First Amendment?
Whose argument?
The people who don't necessarily agree with you.
Who don't agree with me?
Yeah, so the other side.
Oh, well, like Lewis, for example. Lewis says that all the framers meant by including those words, or of the press, was to protect the written expression as opposed to the oral expression of speech, contrasting press with speech. And he, I think, he's certainly right in pointing out that, contrary to Stewart's view, the framers meant to protect the publishers of books and pamphlets, not just news media, not just the press, newspapers, but the press includes publishers of other written materials. That I certainly agree with. But to say that all they meant by of the press is to protect the written word in addition to the spoken word doesn't convince me. I think the evidence, including the evidence that 10 states at the time the First Amendment was written had explicit provisions in their state constitutions protecting the press and not speech, tells you something, that they were concerned about protecting the press in some way. Okay. Different rules for different media. We looked at a lot of cases there dealing with different media of communication, starting with Red Lion. Actually, we started with movies, but and we worked our way through sound trucks as a new medium of communication. But the first principal case we looked at was Red Lion on broadcast, then Miami Herald on newspapers, and whether the same kinds of rules that the court said in Red Lion can be enforced against broadcasters, that is, regulating the content to some extent of what broadcasters put on the air, whether those same kinds of rules, the fairness doctrine, would apply to newspapers. And Miami Herald versus Tornillo, without even mentioning Red Lion, made it clear that print is treated differently from broadcast. Then we looked at Pacifica, which is the fountainhead of the indecency doctrine. An entirely different thing. I had a very nice conversation last week on the phone with Justice Stevens, the author of Pacifica. And he's got to be 93 now. He's right with it. He's quick. He's knowledgeable. And I wanted so badly to ask him whether he regretted his Pacifica decision, but I couldn't do it. Anyway, that's indecency, and then bringing indecency up to date, we have the Fox television cases dealing with Cher and Bono and all of that, and leaving us in limbo about whether the FCC is free to continue enforcing its indecency regulation against licensed broadcasters, over-the-air broadcasters. They don't regulate cable in the same way, they don't regulate satellite in the same way, but they continue. They haven't abandoned it. The law still applies. Pacifica is still good law. They can still enforce, as far as the Supreme Court is concerned, the regulations against indecency on the airwaves. Then turning to the internet, we looked at the various congressional attempts to restrict sexual material on the internet. 4 different laws that Congress passed, starting with the Communications Decency Act in 1996, which sweepingly and vaguely and irresponsibly attempted to outlaw indecent communications to minors or patently offensive material available to minors on the internet. And in this wonderful opinion by Justice Stevens, the court said that the level of scrutiny to be applied to the internet in First Amendment cases is not qualified. It's not anything like broadcast scrutiny, relaxed scrutiny as in Red Lion. The scrutiny must be at least as strict as that applied to newspapers or soapbox orators or other speakers. So the internet has that protection, and this law, the court found, was so clumsy and so overbroad and so vague that it was not narrowly tailored to serve the government's interest, which the court acknowledged that the government has a compelling interest in protecting children from exposure to sex on the internet, but that the law wasn't narrowly tailored to serve that purpose. That was the Reno case, and then the Congress tried to patch up the holes in the law poked by the Reno case and came out with a new law, COPA, the Child Online Protection Act, which narrowed the restrictions to only to the World Wide Web, only to material put on the web for commercial purposes, and said that only material that is, quote, harmful to minors is outlawed, made criminal, and came up with a definition of harmful to minors that looks just like the definition of obscenity, the three-part Miller versus California definition of obscenity, with the words for minors or respect to minors tacked on to each of the three elements. And that law, too, was condemned by the Supreme Court after three, I guess they did have three trips to the court, two decisions by the court in the COPA cases, and the law was condemned as overly broad and not narrowly tailored to serve the government's interest, in part because there was a less restrictive means of serving the government's interest, less restrictive than criminal prosecution, less restrictive of speech, because filters, software filters, would do a lot to contain, they may not be perfect, but they would do a lot to contain the amount of sexual material available to children on the World Wide Web. And then the one case that the government succeeded in, constitutionally succeeded in enacting was the American Library Association case, which involved government subsidy to schools and libraries that use government money to finance their public access computers. And the law required them to install software filters that would screen out material that would be harmful to minors. And the Supreme Court upheld that law, a decision written by Justice Rehnquist, on the grounds that this was a subsidy, it wasn't a criminal prosecution, it was the government using its spending power. People didn't have to take the money if they didn't want to, and that was a reasonable condition the government could put on its grant of a subsidy. And then the last case, or the last law that we looked at was the Child Pornography Prevention Act, which made it a crime, amended the federal child pornography laws to make it a crime to possess or distribute any pictures of what, quote, appear to be children in sexual acts. And the court invalidated that law as well on overbreadth grounds because it would condemn as illegal, for example, movies that involve young-looking actors who were in fact adults. It would condemn some Renaissance drawings, and it would condemn computer-generated images that did not involve children in their production at all. No real people involved in it. And the court reviewed its previous decision on child pornography, and the rationale for allowing states and the federal government to outlaw child pornography is to protect children from being abused in the production of the images. And since there were no children involved in the computer-generated images, the government did not have a legitimate rationale for outlawing those images. The government argued that, well, maybe there's not abuse of children in the production of the images, but the images can be used by pedophiles to whet their appetite or to seduce kids. And the court rejected that rationale as well, basically on Brandenburg grounds, that what you're objecting to here is the planting of bad ideas, and you, government, have not shown that there's a direct causal link between viewing the images and abusing children. So that law, too, went down. On the questions there, can the government compel the media to publish or broadcast information they choose not to publish or broadcast? That's contrast Red Lion, where the government did compel, under the Fairness Doctrine, broadcasters to air information that they didn't want to broadcast, with Miami Herald, where the court said the newspapers could not be compelled to publish information that they didn't want to. And that issue arose as well in the Agency for International Development case that is pending in the court that some of you wrote a paper on. To what extent can the government regulate indecent material in broadcast? Well, Fox Television says they can still do it. Pacifica is still good law. What government regulation of the internet is permitted by the First Amendment? That's basically the four laws: CDA, COPA, CIPA, and CPPA. Then I posted some sample true-false questions from last year's final. So here's the quiz. Number one, First Amendment principles may apply differently to different media because of the characteristics of each communications medium. True or false? True. Indubitably true. The court has said so several